Good morning.
Good morning, Your Honor. Parks Chastain for the appellant Shelby, Ireland, along with my associate Hannah Leifel. I would like to reserve 5 minutes of rebuttal time,
5
please.
minutes, certainly.
We're here today challenging the entry of summary judgment against Miss Ireland by the Murray County Circuit Court, which awarded Tennessee Farmers and the agent a judgment based upon an alleged misrepresentation that was made in a document called a Certificate of Good Health by the decedent Lyndon Ireland. And the argument that we have today is based primarily on the proposition that in order to prevail on a misrepresentation claim, the insurance company has to prove that there was actually a false statement. The very first thing that they have to do is bring forth evidence to satisfy their burden that Mr. Ireland actually misrepresented an existing known fact on this Certificate of Good Health. That's what we challenged in the trial court, and that's what we challenge here today. If you look at that Certificate of Good Health, it's in the record at Volume 2, page 222. There are only 5 general questions that were posed to Mr. Ireland. This was not the first time that Mr. Cox, the agent, and Mr. Ireland had had interaction with each other about insurance. They'd had a whole history, and we've outlined that in the brief. But it comes down to this very one day, and Tennessee Farmers asked 5 questions. The only one that is even relevant or contested here today, and here's the question exactly. Have you consulted or been examined or treated by a physician or practitioner? And in response to that question, Mr. Ireland checked yes. And that is key. He did not misrepresent the fact that he had been treated by a physician. He goes on to have a conversation with the agent. The agent records on that same document that the insured was deer hunting and fell out of a deer stand, went to Williamson Medical Emergency Room, had a mild concussion, had a CAT scan, and was released, was not recommended for any follow-up. That is what the agent wrote on the Certificate of Good Health.
He just left out the part that he was diagnosed with fatty liver disease.
There is no evidence that he knew that he was diagnosed with fatty liver disease, and that's the key. Because if you look back at the Certificate of Good Health, the question says, the representation is, do you represent to the best of his or her knowledge and belief that the above statements are true? Well, the above statement was true. You go back to even the original application where that question was asked about liver disease, and it is still based upon your knowledge and information.
When he was released from the hospital, did he have to sign something acknowledging that he had received the information that he had?
Here's the way that happened. He signed a document acknowledging that he had been provided with all of the records. Mm-hmm. Yes, he did. The question is, and the absolute proof is, and I think we got to look at the practical reality. I don't think practically everybody reads those things. But here's the truth. Miss Ireland presented an affidavit in accordance with the Lane opinion that this court entered, Lane versus American General Life and Accident. She presented an affidavit that said, here's what he was told when he was discharged. So what she says is he was not told anything about liver. He was not told anything about these other problems. He was not, here's the key, recommended for any follow-up.
Except for the actual written document says follow up with your PCP. So to agree with your argument, we have to ignore what's in the discharge summary and ignore the fact that he signed it and acknowledging that he'd read it and understood it.
You don't have to ignore the fact, but first of all, it does not say follow up with PCP. It says advise PCP of liver. It does not say follow up. So when you look at the actual wording, no, you look at what he actually knew. And the question is, could reasonable minds differ as to what he actually knew? Is he expected to read and know everything on discharge that is in those medical records? If this court says, yes, a patient has to know all that stuff because he's represented, he's read it, we lose.
Counsel,
I agree.
In your brief, you make an argument, one, in terms that no exam occurred with regard to liver, and also he wasn't aware. I wonder if maybe the first part of that, the second question on the Certificate of Good Health, consulted or been examined or treated by a physician or practitioner. Now, on the Seen Today for patient signature page, it specifically lists steatosis of the liver as something that he was seen today for. Doesn't that take care of at least the, was he examined? I mean, There's still maybe the argument that he didn't understand he was examined for it, but doesn't that at the very least knock out the fact that he was examined for steatosis of the liver?
No, I don't think so, because he did not make a misrepresentation of that fact. Look back at that certificate of good health. It does not say, what were you consulted for? Here's what it says. Have you been consulted or been examined or treated by a physician or practitioner? Yes, he gave the record, he gave the hospital. The idea of not establishing a misrepresentation is that Tennessee farmers can go get the records. They were able to go get the records. They knew exactly where he was treated. There is not an affirmative misrepresentation. And in fact, if you look at the statements of undisputed fact, Tennessee Farm Bureau acknowledges that there was no misrepresentation no false representation of fact on that certificate of good health.
When he answers yes, the certificate of good health form requires, if there is a yes answer to any of the above questions, give full details in the space below. Is an exclusion of fatty liver, the fact that he was seen for steatosis of the liver, not a failure to provide full details?
It is not an affirmative misrepresentation, and then that's where we get into the knowledge issue. Did he know? Look, you go to the hospital, there's all kinds of medical records, medical reports. Tennessee farmers had the burden to establish, in order to prevail on summary judgment, that there was a false statement. So that's the very first burden they have. And because that form and the original application are based upon being to the best of his knowledge, they can't do that. They can't just say, look at the medical records. He was seen for, he was examined for. This lab test resulted in a fatty enzyme test. That's not what they ask in their question, and there is no affirmative proof that he actually knew that. The question is, to the best of his knowledge, and that's what Lanes did. If we can look at Lanes just a second, Lane versus American General Life Insurance, the wife put down an affidavit basically like we have in responding to the summary judgment. And part of that affidavit said that her husband was seen in the emergency room, and at the time, no doctor or healthcare provider told her husband that he had been diagnosed with chest pain. Well, this court in Lanes found that that was not an actionable misrepresentation because there was no proof that Mr. Lane, the deceased in that case, actually knew he had been diagnosed with chest pain. Because the thing was, is this to the best of your knowledge and understanding? Well, that's what we were saying Mr. Ireland did. He simply said, I've told you what happened. I went to the doctor. I wasn't told to follow up. Ms. Ireland's affidavit supports that. Now, you go to your second question. I'm sorry, you go to your second question. There were, in the Lane case, actual misrepresentations that this court found that were actionable. And one of those was, have you had an EKG recently? Well, yeah, this fellow had had an EKG recently. He'd gone through a cardiac treadmill test. So this court found you can't possibly differ. Reasonable minds could not possibly differ about whether he knew he went through the treadmill test, whether he went through the EKG, but they could about whether he had been diagnosed with chest pain.
Counsel, you said the response to only question 2 is before the court. The briefing in this case from Tennessee Farmers gets into the response to the third question also in terms of realized any fact which require change in the answer to any question or any statement made in the original application. In the original application, he says no to whether he has any disorder of the liver, which fatty liver would seem to trigger a change potentially to that response. I wonder if you could develop a little bit for us why you don't think the response to the third question is appropriately before this court.
Well, first of all, it goes back to the original application. So let's look at what the actual question on the original application asked. And it said, have you ever been treated for or ever had any known indication of that liver problem? So he had never been treated. There's absolutely no proof of that at that time. And there's no proof that he had any known indication. That goes back to the subjective intent of whether or not he was doing his best to answer that question. So even if you consider, Your Honor, the third, which was really not briefed that much in the trial court, but if you do, there's still not a violation because he did not realize, as that third question says, that answer needed to be changed. If he didn't know it for purposes of question 2, he didn't know it for purposes of question 3. So at the end of the day, where we end up with is a dispute that should have prevented summary judgment. I certainly agree, Your Honor, that they could raise that sheet where he signed and said, look, I read all these papers and I understand. That is certainly a fact. But the competing fact is he was not told to follow up. He wasn't told about any of this, as attested to by the affidavit of his wife. Just like in Lane's, that should have been enough to at least let us get to the jury. Thank you.
All right, thank you, Mr. Chastain. We'll hear from you further on rebuttal. We'll now hear from the appellee. Good morning.
Good morning, Your Honor. Hunter Brush, along with my law partner Alexa Hadley, on behalf of the appellees, Tennessee Farmers Life Insurance Company. And
will you be the
Jack
only
Cox.
one arguing?
I will be the only one arguing.
Very good, thank you.
I want to start with the idea that there has to be this known misrepresentation. And we really need to start with the language of 56-7-103, which states, no written or oral misrepresentation or warranty made in the negotiation of a contract for a policy of insurance by the insured shall be deemed material or defeat or void the policy or prevent its attaching unless, and there's two here, unless the misrepresentation or warranty is made with actual intent to deceive, or unless the matter represented increases the risk of loss. While counsel would like for the misrepresentation to have to be known by the insured, that is not the matter at issue in terms of the statute. It's whether what the insured put down is true or false. That is the question on the misrepresentation piece.
Well, isn't the statute really limiting the insurance company from what it can claim as foul versus the application that the intended insured is asked, and that is based upon the best of your knowledge? You can't use the statute to erase your own application question, can you?
I think that you can, because there's a body of law that.
In other words, your client intentionally poses a question to a potential insured, knowing that they don't intend for that to have any effect whatsoever when it comes down to the question of whether there's coverage. Surely, your client isn't operating in that fashion.
No, Your Honor. The questions posed.
So can we get back to it does matter whether this man knew or should have known?
Certainly, Your Honor.
Okay. Now.
In that regard, the facts are really undisputed there. Early in the case, we submitted some requests for admission to Mrs. Ireland. RFA number 23 states, the medical records from Mr. Ireland's visit to the Williamson Medical Center ER on December 29, 2018, true and correct copies of which are attached, indicated that his liver enzymes had become more elevated than they were on November 6, 2018, and indicated that he was diagnosed with steatosis of the liver. Admitted. And then in number 26, despite the medical records from Mr. Ireland's visit to the Williamson County ER on December 29, 2018, indicating a diagnosis of steatosis of liver, Mr. Ireland failed to disclose this fact on the Certificate of Good Health and that he executed on January 24, 2019. Admitted. Subsequently, in the face of summary judgment, we get the Ireland affidavit. Importantly, the Ireland affidavit does not dispute the signature on the patient signature page. It doesn't even say, like in Lane, we were never told of this diagnosis. It is very, very brief. It states, I was with Lyndon Ireland when he was discharged from the Williamson Medical Center. Well, in Lane, the affidavit stated that she was with her husband the entire time. So here, there's no proof that she was with him throughout his ER visit, and no proof that she heard any statements from doctors who treated him. The only proof on that matter is his signature on the patient signature page, which advised that he had a diagnosis of steatosis of the liver. Another statement in the Ireland affidavit: when Mr. Ireland was discharged after his ER visit, there were no recommendations to follow up with a medical professional unless he exhibited symptoms related to the fall from the tree stand. Again, this does not state that she spoke to any medical providers, and it's really in the face of the prior admittance that he signed the patient signature page, which did have recommendations to advise a primary care physician regarding the fatty liver diagnosis. The other statement in the Ireland Declaration: Mr. Ireland was not given any papers recommended he follow up with a medical professional after his ER visit. The follow-up with the medical professional is frankly not as important as the fact that he was diagnosed with steatosis of the liver and advised of this, as evidenced by his signature on the patient signature form, which Mrs. Ireland admitted prior to this affidavit. Again, this affidavit does not speak to that diagnosis at all. It only speaks to her time frame of being with him at discharge and what she heard regarding the concussion, the fall from the tree stand.
Counsel, is there any denial of having read the patient signature form in the affidavit? That wasn't read, wasn't seen, just hurriedly marked down? Any reflection on that in the affidavit?
No, Your Honor.
Now, in contract law, we typically take the position that if someone signs a contract, they are presumed to have read it and understood it. Are there any cases that say anything to that effect in the arena of life insurance or insurance applications?
Well, on the patient signature page here, there is the statement above the signature line stating, "I have read and understood the instructions given to me." So I would submit that that is enough to carry the day on whether he read and understood. He has to be held to what he signed for.
On page 9 of the trial court's final order at the top, it says, upon discharge, Mr. Ireland signed a patient signature page acknowledging that he read and understood the instructions relating to his diagnosis. So it's clear that the trial court made that finding that he did.
So once we establish, and I think we have, that there has been a misrepresentation, because again, those RFAs I cited established that, and Mrs. Ireland's affidavit does nothing to upset those prior admissions. Then the question is simply whether did it increase the risk of loss. The diagnosis happened in December. He came to the office on January 24th, 2019, to amend the policy of insurance that he was applying for. He did not disclose the diagnosis at that time, and 2 days later, it is undisputed that he died of steatosis of the liver. So, does it affect Tennessee farmers' risk of loss? Certainly, and that's evidenced by the fact that questions in the original application asked for information concerning liver disorders. It's also, frankly, a matter of common sense. Of course, the ailment that caused him to expire 2 days later is something that the insurance company would want to account for. And that's what they were in the process of doing when he expired.
Counsel, is the response to the third question properly before this court on appeal? It's in your briefing. Opposing counsel asserts that it's not properly before the court. Is the response to the third question on the certificate of good health before this court on appeal?
I believe it is. The third question, so the certificate of health, not only at the third question, but at the outset of the document, makes clear that it is a document that is amending and is attached to the original application.
Was it raised before the trial court, the response to the third question?
It was not. I will submit, though, again, I do not believe it changes that you cannot read the certificate of good health in isolation. But even if you find that we have to read the certificate of good health in isolation, it is important to note that the language above the signature, of which he is signing there, states, to the best of his knowledge and belief that the above statements are true and complete, and that all details have been given, which would invite a discussion by the applicant to raise all the details he knows about his prior diagnosis, and would show that the diagnosis is important to Tennessee farmers.
Counsel, you do raise the argument, you raised the argument for the trial court that there was no policy at all here. There's something on the life customer service request that I'm struggling a little bit to understand, and maybe you can help clarify this. Under special request, it says, please redate policy 1/24/2019. What is that a reference to on the life customer service request form?
Certainly. So this is a matter of practice within Tennessee farmers for the same reason that at the time somebody comes in to fill out an application, a policy number is on that document. Policy number is assigned right away. The redating of the policy goes, in terms of their internal workings, it's whatever the last document that is being submitted in towards applying for the contract that the company dates. I also
Is that a start date for the policy?
Assuming that the conditions precedent are met, it would be a start date. And here you had two that were not met. And I think this is undisputed as well. Obviously, he comes in on the 24th. He discloses this fall from the tree stand, the concussion, and the CT scan. That, in and of itself, regardless of the fact that we didn't know about the diagnosis at that time, caused Mr. Ireland's application to go back to underwriting. It is undisputed.
Doesn't that suggest there is a policy that's potentially subject to cancellation rather than there's no policy?
Well, the application itself states the condition that, and states, I agree, I being Mr. Ireland in this case, that no insurance will take effect unless, C, there has been no change since the date of his application in the insurability of all persons proposed for insurance. So it is a condition precedent to it. The underwriting has to happen because they have to know what risk they're ultimately taking and how to price it. That's undisputed that underwriting has to happen first before a policy can be delivered. Mr. Cox.
In all cases, or only when they've checked one of the boxes?
Only when they've checked one of the boxes, and that's an important distinction here because counsel raised that Mr. Cox and Mr. Ireland had prior dealings, and in his briefing, he pointed out that before, with his 2012 policy, which Tennessee farmers paid upon, there was an instance where he had to submit a certificate of good health, and there was no underwriting done at that point, and that is because, according to Mr. Cox, and there's no contrary evidence, there were only no answers on it.
On the prior occasion, a conditional receipt was provided, though, right? And in this circumstance, a conditional receipt was not used in terms of what the receipt that he received for his payment on the policy.
That is correct. A conditional receipt was not used here. A simple receipt was provided, and it was provided, according to Mr. Cox, because he wanted to collect payment so that, assuming everything came back fine with the underwriting, that there was going to be no further holdups to the policy, because one of those other condition precedents is payment of the first month's premium. So he was simply trying to fast track. I want to conclude with this. Counsel states in his brief, how can a false statement have been made if he disclosed the fall from the tree stand? I think the vital point that he is missing is not that it is just what's actionable is not just misrepresentations, affirmative statements, but also omissions. And that's what we have here. And it's clear that he knew about it, even if that is the standard. Thank you.
All right, thank you, Mr. Brush, for your argument. Mr. Chastain, your rebuttal.
Thank you, Your Honors. I want to address a couple of questions that you raised with Mr. Brush. Going back to the question about the medical records, I want to draw your attention to that Lane opinion again, and it's talking about what if the medical records tell something that is a different story than what the insured says. And here's what it says: because the insurance policy requires the applicant only to answer the questions to the best of his or her knowledge and belief, we do not believe the statute mandates a loss of benefits when the questions are answered to the best of the applicant's knowledge and belief, even if, and here's the key language, even if the answer is wrong and the insurance company can show an increase in the risk of loss. For example, taking wife's affidavit as true, which the trial court should have done, when Mr. Lane indicated he had not been diagnosed with chest pain or having had a mild heart attack in the past, that response may have been true to the best of his knowledge and belief, again, key language, even though it was wrong and the medical records themselves would have established otherwise. So look, there is clearly a contradiction between what the medical records say and what the evidence shows Mr. Ireland knew. But because all of these questions, even that representation about the certificate of good health, are based upon his knowledge and being to the best of his knowledge and information, we have to look at that and we have to conclude that there is a disputed issue of fact.
So is there any denial in the affidavit that he read the patient discharge information? Is there any sort of express addressing of how he read it or didn't read it? Or
No, there's not. No.
How do we know from this record what Mr. Ireland did not know? And I asked that question in the context of, as Judge Usman just mentioned, he signed the discharge paper saying that he read and understood what was in it. So that would mean that he understood that he had this diagnosis. But you say the record indicates that he did not know. What evidence is there in the record to support a finding that he did not know?
The evidence in the record to support the finding that there was no misstatement, and that's what I've got to respond to you on, is the affidavit of Shelby, Ireland. It does not address the fact of whether he read and understood everything, but what it does say is that the representations made on the certificate of good health, specifically this is where I went and I was not recommended for any follow-up, were true. That she did not hear in his, because that was on a discharge summary, so that's why the affidavit referenced discharge. She did not hear anybody tell him, hey, you need to follow up on this. You need to go seek other treatment. So what he put on that affidavit, or what he put on that certificate of good health, is what she put on the affidavit. That's our proof. Because again, they have to prove a misstatement. That statute, 567103, says no misrepresentation or warranty. I think, as this court pointed out, Tennessee Farm Bureau is trying to avoid the bad question that they ask. Had they wanted to ask it a different way, they certainly could have asked it a different way. But all of their questions were phrased to the best of your knowledge, and they were vague.
Counsel, even if, let's assume for purpose of argument that his understanding is there was no recommendation of a follow-up. Isn't there still an examination here? And there's a finding on, it says fatty liver, and the affidavit doesn't say the form wasn't read. So I'm looking at that. If there's a finding of fatty liver, I have to have been examined and in some form to have that conclusion reached on the discharge paper. So even if there's no follow-up, or his understanding was there was no follow-up, isn't there still an examination that he has to give detail as to?
Well, he did. He gave the examination that was taken at Williamson County Medical Center. He described this. And don't forget, these liver enzymes, as we've briefed, were already known by Farm Bureau. These tests came back in December 2018 showing this enzyme issue. So this is not something Farm Bureau didn't know. He comes into Mr. Cox's office, and to jump, I'm running out of time, let me jump to that last question I think you asked, Judge Usman. He said that why did Mr. Cox take the money? In record page 251, we submitted a statement that said, based on what Mr. Ireland told Mr. Cox on January 24th, Mr. Cox did not think it was going to impact Mr. Ireland's insurability. Response, undisputed but immaterial. The reason he took the money is because this was not a big deal. Mr. Ireland explained to him, and you'll note that Mr. Cox is the one who wrote the explanation in the record for what was done at the hospital. But there was no misrepresentation by Mr. Ireland. And unless and until they prove that, there should have been a trial. They can argue all this at trial, but there should have been a trial. Thank you.
All right, thank you, Mr. Chastain and Mr. Brush, for your arguments. We'll take the matter under advisement.